Hello, everyone. Welcome to Court with Krissy. Please don't insult the intelligence of the pro se. He voided the objection. And then, it's an update I was not expecting. Does the judge slam the hammer and divorce them? I hope you like it. Court with Krissy is now in session.
All right, Mr. Collin, are you able to hear me okay?
Yes, can you hear me?
I can, thank you. All right, we'll go on the record. This is Collin versus Collin. This is Crawford County file number 2411622. As the parties can tell, I'm conducting this hearing today by video from Otsego County, but both sides are connected by Zoom. We also have the front of the court connected. This was set for a scheduling hearing today on some objections to referee's recommended order. Because I don't have the file here with me in Otsego County, Mr. Vernon, are those your objections?
No, they're Mr. Collins.
Okay.
Can you
Lost
you there?
Oh, you're back. Okay. So, Mr. Collin, you filed some objections to the referee's recommended order. Is that correct?
Correct.
Okay, so the court will set this for a hearing. Mr. Collin, how many witnesses did you have testify at the hearing before the referee?
I believe 8.
Okay, how long did that hearing take when you guys had that?
2.5 hours.
All right, Mr. Vernon, how many witnesses did your side have testify?
I think there were 4.
Okay.
They had 2.
Can't remember who we called, but we had 4 that we subpoenaed. I can't remember which ones we called.
Okay. All right. So for the hearing that we'll schedule in this case, the court will not take testimony from the witnesses that already testified. I'll review the transcript, so I'll be able to see what they testified to. The court will only take testimony from witnesses who did not testify at that hearing. And then any testimony about things that have occurred between that hearing and the date of the hearing that we'll have. So with that in mind, Mr. Collin, how many witnesses do you think you'll have?
From this point forward, just myself again.
Okay. And Mr. Vernon?
Would probably be just 1, maybe 2.
Okay. So I'm going to set this for a half a day evidentiary hearing then. And the court will set that for the soonest possible date. We'll send out a notice of the date and time of that hearing to all parties. And we'll go forward from there. That'll be an in-person hearing in Crawford County. So all parties will need to appear at the court for the date of that hearing. The only other thing I wanted to address today, Mr. Vernon, you filed a motion to adjourn the mediation. Is that correct?
So we actually filed several. We filed a motion in order to show cause why Mr. Collins not cooperating with an appraisal on the home. We filed a motion to compel discovery for release information related to some financial information. And as a result of all of that, we did ask the court to allow us to extend the deadline for mediation because at this point we can't, there's no benefit to mediating until we get that information.
All right, Mr. Collin, do you have any objection to adjourning the mediation until we can address those issues?
No.
Okay. All right, I'm going to put the, I agree that without that information, or unless Mr. Collin has a valid reason for not disclosing that information, mediation probably would not be helpful. So the court will adjourn the current mediation date. Mr. Vernon, if you can submit an order that reflects that.
We will.
I'm gonna adjourn that without date. I'd like to get those issues addressed, and then I guess I'd like to have as part of those hearings. Do you have dates for those already, Mr. Vernon?
Yes.
Okay. So we'll address mediation further at that time as to whether or not that's something that the parties feel would be beneficial or not.
It appears February 6th is the date.
Okay. All right.
I did have one other thing, if the court is so inclined.
Yes.
In our answer to Mr. Collins' objection, we identified, and I know you identified that you don't have the file in front of you, but we did identify as our first paragraph that Mr. Collins' objection is untimely, it's late. And as a result, we were asking the court to not consider it and simply dismiss it because it's late. The information he asserts in that objection is simply based on a review of the evidence, and he doesn't think that the referee properly reviewed that. So again, he's not asserting any legal error or any factual error. He just doesn't like the manner in which she considered it. So what I would ask the court to do is, one, dismiss this because it's late and he lacks good cause for having filed late. Or we would ask the court to simply limit its review to the record and not take new testimony. I know Mr. Collins not represented by counsel, but my client is, and every time we have to appear in court, it costs her more money. There's nothing new here. There's nothing that that's being argued. The objection that has been missed. So I think if the court were to review the record, that would be sufficient to answer the questions set forth in the objection. Again, if the court chooses to review the objection at all, because it's untimely.
All right. So to me, those are two issues. One is regarding the scope of the de novo review, and the other is a procedural issue. So Mr. Vernon, if you're asking the court not to conduct the hearing at all because of a timeliness issue, then I think that needs to be a motion that you need to file and set for hearing along with the other motions in February.
Well, we started it as an argument in the answer.
Well, then that's fine. That's fine, but it's not gonna be up for a decision on that until the date of the de novo hearing, if that's the procedure you want to follow. So my suggestion is, if you want to avoid having your client pay fees to prepare and be ready and be at that hearing, that's something I think that could be determined, because it's a procedural issue and I think it's a threshold issue.
May I say something?
Yeah, just 1 second. That could be dealt with by way of motion. So I'm not going to rule on it here today. I don't have the file. I have no idea what the dates are, and it's not been set for a motion here. So I guess that's up to you, Mr. Vernon, if you want to wait until the day of the hearing and address it at that time as part of your objections, or if you want to file it as a motion prior to that. If we already have things set for February 8th, I am willing to make time for that so that everybody doesn't prepare for a hearing that's not going to happen if indeed the court were to grant a motion. So, Mr. Collin, go ahead.
Yeah, his objection is not valid to the filing improperly date, because I was actually notified that was the last date to file by the friend of the court when I filed as well. So that objection is voided already once you look at that date, the dates. And the other objection, or if she was intelligent, she wanted to save money, she wouldn't use the child support to support her attorney, and we could do this outside of court simply without him as well, to save her a lot of money. So that could be something she thinks about as well.
All right, so the first point I think is a good point. That's why we need to have a hearing, so I can hear both sides and make a determination as to whether it's not under the court rules. The only other thing I would say, Mr. Collin, is, nobody's making personal insults directed at you here on the record. I think you'd be well advised not to insult anybody else's intelligence as part of this hearing or any other hearings. That it's not going to help your case, and personal attacks are something you can do on your own time. It's not appropriate for the record. Okay, so I'm going to ask you not to do that going forward.
I was just giving her advice, actually.
Did you hear what I just said?
Yes.
Do you think you can remain civil and not insult the other side during our court hearings while we're on the record?
Yes, Your Honor.
All right, I'm going to ask you to do that going forward. Thank you. So that's all for the hearing today. The court is going to put that de novo hearing on the record for a half a day. Again, send out notice of the date and time of that. Mr. Vernon, if you want to raise the timeliness issue, other motions in February, we can address those at that time. Otherwise, we'll address all the objections and responses to that at the time of the hearing. That's all I have for today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
All right, Mr. Vanderkerchov, are you able to hear me okay?
Yes, I am.
All right, we'll go on the record in Vanderkerchov versus Rapley. This is case number 2419803. Record should reflect that Mr. Vanderkerchov is present today by video. This hearing was set for 10:45. It's now 10:50. I do not see Ms. Rapley connected. This was set as a hearing today for entry of a final judgment of divorce. Mr. Vanderkerchov, I do not see a judgment.
No, I have it in my hands. I was not able to contact her to get her to sign this at all. She has me blocked on everything, so I had no ability to contact her to get her to sign.
Okay. All right. Does that judgment of divorce award you any kind of specific property, or have you guys already divided everything up?
Yeah, everything's already divided. There's nothing to really, there's no property, the vehicles, or each party will keep their own vehicles in their name. And everything's divided. I don't see anything in here with division.
Do you own any real estate or real property together?
No.
Okay. All right. So based on Ms. Rapley's failure to appear today, I can put you under oath. I could take the testimony that I need to take from you. And then you can drop that judgment of divorce off here at the courthouse today. And we can talk about that a little bit more, but I can sign that once you drop it off, and then the divorce will be final without the need for further hearings. Did you want to do that?
Yes, I wouldn't need her signature at that point.
Because she's failed to appear for this hearing today, essentially I would be fining her in default. So to the extent there would be a to contest, she wouldn't really be able to do that. So there's really no reason why we can't go forward. The only thing is the divorce won't be final until you drop off that judgment and I sign it. So it's a really important step for you to follow through with. Otherwise, this will just be hanging out there. Yeah,
no, I'll go there right after I'm done on this meeting with you.
Okay. Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Vanderkerchov, you filed the complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
To your knowledge, is Ms. Rapley currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And you've indicated today that you and Ms. Rapley have divided up all the property and debts of the marriage and that you don't own any real estate or real property together. Is that true?
Yes.
All right. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Vanderkerchov. the court will grant the divorce. Although again, Mr. Vander Kirchhoff, because I've taken the testimony, that's not, the divorce is not final again until you turn in that judgment and I sign it. So I would encourage you to do that as quickly as possible. And then you can get a copy of that for your own records when you turn that in as well.
All right, thank you very much.
Do you have any questions at all?
No, sir.
Okay. All right. Thank you. That's all for today. And you're free to disconnect at this time.
All right, thank you very much. Bye.